In less than an hour, former President Jacob Zuma's arms deal corruption trial is set to get underway in the Pietermaritzburg High Court. But Zuma is planning a new bid to try and remove the prosecutor, Billy Downer, while some experts say there is no way that this move would impact the case. Let's hear what another legal expert has to say. Nthabiseng Dubazane is talking to us, trying to make sense of this particular case. Nthabiseng, thank you very much for your time. Let's start with the Director of Public Prosecutions in KwaZulu-Natal refusing to enroll the matter. And this is after the former president went to a police station to lay a charge against Billy Downer. He's now seeking a private prosecution. Is that going to move at all?
I think they would have to put in an application today, the legal team, to request a postponement in order to give them a chance to deal with the process of applying for private prosecution. Because by virtue of the DPP refusing to enroll the matter, I believe they should release a certificate of nolle prosequi in terms of Section 7 of the Criminal Procedure Act. So if they're able to move the DPP to allow them to proceed with the criminal matter after they refuse to continue with the matter, therefore it might give them grounds to apply for the court, today, to have this matter postponed instead of the trial actually continuing, and give them a chance to make this application to start the private prosecution process.
All right, so it might likely have a bearing on whether or not the trial, the actual trial of the former president does get underway. Am I correct?
Yes, it might. However, looking at the history of this matter and the fact that the recusal application was held within the same court that he's appearing today and then dismissed, and then that was also confirmed in a higher court, the presiding officer might be inclined to refuse a postponement up until such a point whereby perhaps they are successful while they're doing, because they can go parallel, they can actually go side by side. The trial can proceed while they are applying for the private prosecution. However, I don't think that would be a good idea, because let's say it is successful, that private prosecution is granted to them, and the matter is now part heard, then it would mean that there has to be another prosecutor that takes over from Billy Downer. And usually that means postponement for transcripts in order for the new prosecutor to understand what has been happening, get notes from Billy Downer, and all of that in order to continue where he left off. So it's a little bit of a tricky situation, I think, for the presiding officer to decide on whether or not to grant such a postponement.
And while on this matter of whether or not these two cases could go parallel with each other, the attitude of the NPA is very clear that this is an intimidation tactic from the part of the former president and his legal team, and therefore they're not going to be intimidated. While they're saying that on the one hand, the judge who is going to be presiding over this matter, I think he has been indicating for some time now that he is going to be less patient with the things that seek to delay this trial. What might his attitude be?
Like I said, I really don't think he will be very inclined to grant them this postponement that they will be requiring today, mainly because this matter has been dealt with in the sense of the application for recusal. Although the criminal matter stems in the manner of form from the recusal application, but it never was put on the court roll as a result. However, I feel like it has been ventilated a lot in the application that was before this current judge or presiding officer, and also on appeal. So the court might say that, you know what, let us proceed with the trial, and if at the end of it you are found guilty, then you have recourse to all these other aspects that you're trying to do prior to evidence being laid. That's what I think might probably happen. However, we are all entitled to exhaust all avenues of the law that are available to us. So is Nthabiseng Zuma. So as a result, if he's going to, because he's going to raise the issue that he feels that he's going to be Billy Downer is going to be biased against him throughout the proceedings. And if that trial continues in that manner, he might just, might just be seen as a hostile witness, for example, when he goes onto the bench and gives evidence, because he would be of the opinion that the proceedings thus far are prejudicial against him. So it is a little bit of a tricky situation, but I don't see the presiding officer granting a postponement based on those past occurrences.
All right, so that's Judge Piet Koen, who might, decide to rule whichever way he does decide. There is another judge here that is being petitioned by the former president, and that is the Supreme Court of Appeal Judge President Mandisa Maya, and hers will be to decide whether or not she is going to entertain the what is called the reconsideration application by the former president Jacob Zuma. What do you understand of this? Because the former president in a way, he keeps teaching us about the justice system in South Africa and the various loopholes that I suppose you can explore.
Yes. So remember, after the presiding officer, Judge Koen, had decided that there is no platform or merit, rather, for the recusal of Billy Downer. And that resulted in this matter going to the SCA, where it also failed because of lack of merit. This failed as a result of, by virtue of pleading not guilty, the trial had already commenced. So the state's argument in the first recusal application before Judge Koen was that this is not the time to apply for appeal in criminal proceedings. Appeal ought to be applied for at the end of the proceedings when the judgment and sentence are given if the accused is found guilty. So they used a loophole whereby you can be able to make this appeal to the SCA, which they did, but they were not successful based on the very same grounds that the matter is not yet concluded and is not ripe to be brought before the SCA. So now what they are trying to do is say, okay, as a result of this decision in the SCA, we are petitioning Judge Maya to say, look at this in the way that we are asking you to, in a different light, and not by virtue of a criminal trial having commenced because evidence really has not been laid. But in the literal sense, the trial has begun as a result of them having pleaded not guilty. So Judge Maya is now going to be tasked to look at their application to have Billy Downer recused and see if it has any merit at all before any evidence is laid. It will be interesting to see what Judge Maya does about this. If she upholds her colleague's decision that there are no merits, then we continue with the trial. And if she says, okay, you do have a point, I do believe Billy Downer should be recused, then the matter in terms of that, I forgot which section it was, I apologize for that, then it would mean that the matter can be dismissed in its entirety because the prosecutor that was proceeding with the matter did not have locus standi. That's why they waited for the accused to actually plead not guilty first before they made this application.
Nthabiseng Dubazane, thank you very much for that legal analysis and giving us a sense of what we might expect to come out of the Pietermaritzburg High Court today.